So in terms of steps on ramping up the aggressiveness on trying to get these things resolved, we talked a little bit about last time about requesting IDRs should be like the first step in most of these cases.
It tends to be, but it depends on the intensity of the tyrant.
Okay.
Because you also don't want to subject yourself to just a horrible meeting if you don't have to.
Yeah.
If there's
okay.
if there's other methodologies available to you, IDR may not be appropriate if you think it's just going to be a shouting match. I'm Luke Carlson, and for almost 2 decades, my law firm, L.S. Carlson Law, has been at the forefront of defending homeowners against overreaching HOAs. We're not just leading the charge, we've created the go-to playbook on how to fight back effectively. Join us as we delve into the world of HOA disputes, sharing insights from our extensive experience and landmark victories. Throughout this podcast, we'll bring you in-depth interviews, demystify complex legal principles, and provide practical tips to safeguard your rights. While the information provided shouldn't be taken as legal advice, our aim is to empower you with the knowledge, strategies, and real-life success stories needed to navigate and overcome the challenges posed by overreaching HOAs. Hi, I'm Luke Carlson of L.S. Carlson Law. Welcome back to the show. Today we are going to continue this theme of bad actors within an HOA. Now, L.S. Carlson Law operates in California and Florida, and over the last decade or so, we've seen a consistent theme of certain characters that really drive bad HOAs. Last week, we discussed the meddler. This week is kind of exciting because we're talking about the tyrant. Today, we have Jenny Carlson on the show as well.
Hi, thanks for having me.
Thanks for being on the show. And we have Marty.
Good morning.
So the reason, one attorney, 2 non-lawyers, we do this in order to ensure that we cover everything. Sometimes when lawyers discuss these topics, they get too myopic on legal issues, and I think this is a good balance with that. So how would you guys like to start?
Well, I think you did the intros pretty well. So let's just dive right into it and identify, what is the tyrant?
Okay, so the tyrant's interesting, and I want to draw a distinction between a tyrant personality and a meddler, because often some of the results are the same, but I think the characteristics are different. Because as I see the meddler, that's the individual in the HOA who has just way too much curiosity. They're up in everyone's business.
Just loves to be involved.
Correct. But what they don't have is the malice, which often drives the tyrant behavior. So as I see it, the tyrant is driven by sort of malicious drive or motivation, or they just want power for the sake of having power.
So the distinguishing factor is malice?
Maybe so, to an extent, or power, or the procurement of power, versus the meddler who just likes to be up in everyone's business. I don't know if there's an end game with the meddler. They just kind of
And these are
meddle.
all HOA board members assumed, right?
Correct. Board members or directors of the board.
Okay. Yeah, makes
So
sense.
so when you have a tyrant, the problem is, and we came up with a good list of this, and I like this, so I'll break it down, but these are the common traits and behaviors that we see. So authoritarian leadership. So what does that mean? In my mind, or what we've seen, is the tyrant takes control of the board. It's not an open forum. It's their word, and everyone else just has to obey, irrespective of whether they're right or wrong, and they shut down commentary, even if it's constructive. So that's what we mean by authoritarian leadership. Lack of transparency is also an interesting one. Tyrants often operate somewhat in the shadows. They do things without notifying everybody. Why? Because often what they're doing is they're overreaching or crossing a line. So that's something to look out for. Unilateral decision making also is sort of consistent with that authoritarian leadership, right?
To me, that means control. Unilateral decision making just means I want control.
Control or power.
Correct.
Right? So that's what they're seeking. And when they do it unilaterally without input, they're exerting control over the board, but also over the community as a whole. And when you see that behavior, the real problem is, well, one, it is inconsistent with the spirit of HOA law in general, but you start to see decisions which favor that individual. So they're not looking out for the whole community. It's self, it benefits them individually.
And I would assume the people that are in their inner circle, or that they want to grease their palms or be able to.
Yeah, sometimes you have a pool of tyrants, right?
That sounds fun.
Yeah. All right. Disregard for due process. Again, if they were to follow everything by the book, they probably wouldn't be able to get the control that they want. So due process is a set of rules and regulations that surround HOAs. So when a decision has to be made, typically there's steps to do it. There's a vote. There's input from the community. They short circuit it and they just lay it down.
Now, people can often get confused with a tyrant just because, I mean, the CC&Rs and rules and regulations could be quite restrictive, and those people are just enforcing those rights. So it's not to get confused with just the people that are literally going book by book. These are people going outside of what the book says just to make life a living hell or to benefit them personally in some way.
Yeah, so I think what you're discussing there is you have two things. CC&R's bylaws really set the framework of how a board needs to operate.
Right.
These are the tripwires. This is how you need to move something forward. The tyrant will disregard those.
Right. That's what I'm getting at.
And operate offside the playbook or outside of the playbook. So
Yeah.
that's really what you look for when it comes to a tyrant behavior. Are they following the
Right.
bylaws? Are they following the CC&Rs? If they're not, you have a problem.
Sure.
Let's see what else we have. Intimidation and bullying. So how we see that manifest, it's interesting. Sometimes what they'll do is they'll take the CC&Rs and weaponize them. And what do I mean by that? Well, let's say the tyrant doesn't like one individual homeowner. And all of a sudden that homeowner is getting fines, is getting violation notices, is being called to hearing. Well, to the extent that that individual owner is actually violating the CC&Rs, there's nothing wrong with the board enforcing the CC&Rs.
Right.
But when it's targeted, right, when it's against one person that they just don't like, that becomes problematic.
Sure.
Right? Or maybe you get a situation where you have the pool of tyrants, they're all violating the rules and regulations, but they're not being held accountable. That's also problematic.
We have the tyrant and the meddler. The meddler is helping the tyrant to weaponize a single homeowner.
Yeah, you get some weird dynamics in these.
And a single individual can cross multiple personality traits too. They could be not just a meddler, but also a meddling tyrant.
I suppose
Or
that's
narcissist.
right. Yeah, so this isn't a psychology show. It's supposed to really focus on personality. So I don't know what drives it. And yeah, I suppose you could have mixed personality types within the personality type of the tyrant.
Yeah.
So, yeah, this is a nice one. I like this label or sort of description. It's a resistance to accountability. So how you see that play out is homeowners are up in arms and they lodge complaints against the tyrant. The tyrant will do everything they can to sidestep any sort of accountability for their action.
We call that lack of ownership.
Lack of ownership or just a disregard, just ignoring what's happening, right? They just push it away, and they can sometimes work within a HOA board. Maybe they're friends with the attorney of the board. And somehow they've worked out a deal where the attorney goes to bat for them and strikes down the complaints. So there's different ways that a tyrant can sort of maneuver, but ultimately, to your point, to avoid that accountability. Yeah.
And this could get really problematic if it's like a board president or someone that's usually kind of top of the heap of the board.
Correct. Yeah, they're in a position where they can do it if that power goes unchecked.
Sure.
Which is, I guess, the other part of this conversation. How do you keep that tyrant from?
Checks and balances.
Yeah.
Yeah.
Personal agendas. I kind of mentioned that, but again, it's power for power's sake, I suppose. But also, you'll see undercurrents of self-interest. They want to push an agenda because it benefits their property, even though it's not benefiting anyone else. So take a common area, for example. Let's say there's a landscaping budget, and somehow all of a sudden most of the landscape budget goes to the green belt in front of their property, while they ignore other pieces of the community, right?
Right.
Self-interested, right? And
Sure.
they've taken their position to drive that self-interest, right?
Yep.
So that's
Makes
what
sense.
we're looking at there. Okay, so dissenters, yeah. So when you have dissenters in a community, and those are the people who are vocal, who are saying, hey, this isn't right, you can't do this. What about the other green belts? Sometimes what you'll see as a result is sort of this retaliation against, the tyrant will retaliate against those complaining. So all of a sudden, if you're complaining a lot, now you're getting violation notices. Now you're under scrutiny. So again, it's this notion of weaponizing the HOA and the tools at their disposal against certain individuals.
But that can be dangerous because then it sets a precedent. Well, I'm just not going to rock the boat because I'm not going to say anything because I don't want the fees and fines or the wrath to come down. So it could.
Correct.
So then the authoritarianism can
It's
keep to
self-perpetuating.
rise. Yeah.
100%.
Correct.
Yeah.
Yeah, if you leave it unchecked, you don't enforce, it becomes a vicious cycle.
Sure.
Without
And I
question.
feel like more than anything, you see the homeowners that don't want to be in the spotlight or the homeowners that just don't want a target on their back.
Right.
So they're going to quietly sit in the background and
Yeah.
have to stay there.
Yeah. So that's problematic, obviously. All right, so what else do we have? Warning signs and how to curb the behavior. So I think the traits really will give you the red flags. I think you can spot a tyrant a mile away. Again, it's someone who's just taking control. Their decision-making seems to be driven by self-interest more so than the good of the community.
Right.
And I would assume their lack of transparency, not providing any sort of rationale or context behind decisions that they're making would be another way of identifying
Correct.
a tyrant.
Yeah. I think the big one, though, is really that targeting or the preferential treatment. If you start to see that byproduct from a board, you might be dealing with a tyrant.
Sure.
So that is things to look for. So I think the big question ultimately for a homeowner is, what do you do with a tyrant?
Yeah.
How do you enforce?
Yeah.
So there's different ways, at least in California, to really push back, but you want to be strategic and you want to be intelligent about how you do it. So, one of the opportunities any homeowner has in California is to demand what's called informal dispute resolution. It's under the Davis-Sterling Act, and it's essentially you're going to come up with a list of wrongs. You're going to say, hey, you did this wrong, you did this wrong. I need to bring this to the board's attention. You can demand IDR on the board, but ultimately what I see when we're dealing with a tyrant, you're going to show up at the IDR, which is really just an informal meeting, and the tyrant's going to be there. And given their personality, it's more likely than not than that individual is just going to get shut down.
Yep.
The tyrant's not going to hear it.
Mm.
And so it can be a colossal waste of time and energy to go through with IDR, but it is at their disposal.
Is it so in terms of steps on ramping up the aggressiveness on trying to get these things resolved? We talked a little bit about last time about requesting IDRs should be like the first step in most of these cases.
It tends to be, but it depends on the intensity of the tyrant.
Okay.
Because you also don't want to subject yourself to just a horrible meeting if you don't have to.
Yeah.
If there's
okay.
if there's other methodologies available to you, IDR may not be appropriate if you think it's just going to be a shouting match.
Interesting, because I would have my assumption would have been, well, we have to go through these steps and to lay out a timeline or a frame of reference here to get to that point.
Yeah, IDR isn't mandatory.
Okay.
It's a step. It's available in a well-functioning HOA. It gets traction.
Sure.
Because it forces the board to sit down with you and you can air your grievances. And it's, the spirit is really collaboration and trying to sidestep legal action,
Right.
right? You're trying to diffuse these situations internally within the HOA, not bringing it out to legal. But again, with the tyrant, you might not get any traction.
Could be tough. So it's one of those, it depends.
It depends, yeah. It's a fun legal phrase that we use often. It depends.
It depends.
So it will be the second step of ramping that up. So we identify the tyrant is, it's not going to go anywhere. This person's out of control. So what's, level number 2?
Yeah, so I think what's mission critical for any homeowner who's experiencing this is creating a file of some sort. You got to have examples, something concrete, something that you can point to, and you start collecting this. Ultimately, it's considered evidence, right, against the tyrant. But you want to show up eventually to a lawyer and present the case. And really the lawyer's job is to go through your files, say, okay, this is a potential breach of the CC&Rs. This is a breach of fiduciary, and start framing it out legally. That's sort of step one. You got to make sure that the conduct of the tyrant actually violates the owner's rights.
Sure.
Because without that or without something credible, you're going to be throwing money at a lawyer, and the lawyer's not going to be able to do much with your case. So assuming you meet with the lawyer and you are able to identify, okay, this has crossed the line and this is why. This is self-dealing. This is targeting homeowners to the exclusion of others. This is preferential treatment. Here are your causes of action. At that point, the lawyer really would have two options, I would say, that I think would be pretty reasonable. One would be to fire off a demand letter to the board identifying the misconduct. And what's interesting about that is when a lawyer sends a demand to an association, you got to remember an association is an entity. It's a legal entity.
Yeah.
And more often than not, they're represented by counsel. So they have their own lawyer. So in an ideal situation, your attorney prepares the demand, sends it to the other side, and a lawyer gets their head around what's happening. Now, a good lawyer, to the extent that there is breaches of these fiduciary duties, should be able to call your lawyer and try to strike some sort of resolution. Because you have to realize, too, that attorney may represent 17 other associations.
Right.
The attorney may have no idea what's happening with your association. So that could be an effective way to get an adult in the room on the other side and open up those lines of communication. And again, it bypasses sort of that informal dispute resolution process where it's owner and board.
Yeah.
You're sort of elevating the dispute.
Yeah.
Downside of that is if the association attorney has been poisoned, it might be a waste of time. Because even if you have a brilliant attorney, the attorney calls their attorney and that attorney just shuts down your attorney. Okay, that's kind of the end of that exchange, right? Because you don't want to keep paying your lawyer to negotiate with a wall. If that attorney is stonewalling your attorney, you're wasting money. You're not getting traction.
So then where does this go?
So the other strategy, at least in California, that you can deploy is a demand for alternative dispute resolution. And I think we've discussed that in the past.
Yeah, we have.
A little bit. You want to recap it just real quick?
Yeah, essentially what that is it's different than a simple demand letter, because if you send the ADR under the Davis-Sterling Act for breach of fiduciary, breach of CC&Rs, et cetera, you actually force the HOA to respond first and foremost within 30 days. So it's a legally charged document. The demand letter, in theory, they could ignore it, and there's no ramification.
Sure.
So you start to put legal pressure on the board, and majority of the time, an association attorney will accept the mediation. They'll agree to it. Because if they don't, there's a waiver of certain rights. I don't want to get too technical with it.
Yeah.
But if you have that agreement, eventually where this lands is in the camp of a mediator, often a retired judge, and that retired judge is, in theory, a neutral who's supposed to facilitate a resolution. So now you have, in theory, a real adult in the room negotiating a resolution. And if the conduct is so egregious, it's highly likely that the mediator is going to capitulate and say, yeah, this is awful conduct. This is a bad HOA. And now you have really good lines of communication open with the association. You have a neutral third party. And that's where you might actually be able to get traction.
Let me ask you this, though. Let's just say that you do win. How do you, in my mind, I'd want to get the cancer out, to get the tyrant off the board. And, if they're in cahoots, even that lawyer out of there, how can a judge say, hey, you've violated so many things here, we can throw you out? Or is it
No, so I have to make a distinction with mediation.
Sure.
Mediation, there's technically no win or lose. It's a negotiation.
Okay.
So even if the retired judge comes to you and says, oh my God, this is a wonderful case in the sense that you have the evidence, this is a really bad HOA, in theory, that retired judge, mediator, could go over there and the other side could say, go kick rocks for doing nothing wrong. And there's no resolution. I would argue that's a failed mediation at that point, right? Because you didn't actually agree to anything. And at that point, the owner would be forced to consider potentially litigating this dispute, which, if you can, you want to avoid that because it's very costly. It's a timely process.
Sounds like it's the last resort.
Correct. Alternatively, though, if the mediator can influence the other side, get them to see reason, you might be able to structure a resolution that everyone's happy with. Now, we've seen it historically where the board president has been removed, self-selected out.
Okay.
Yeah, where they say, you know what? This is too much. I'm a volunteer. While I love being a tyrant, it's not worth it. So you have to understand mediation in the truest sense is a negotiation. It's not a win or lose proposition. Now, you may come out with an outstanding outcome, but it wasn't because the mediator said you were the victor.
Sure. Is this ever a point where you go to arbitration versus mediation?
So that's a good question. So arbitration is a form of litigation.
Right.
And typically arbitration is triggered by way of a contract. You have a contractual right to arbitrate versus taking it to state court, right?
Okay.
So with arbitration, in order to get into arbitration, there's two ways. One, everyone will agree that that's the best forum. Or if there's a contractual right to do so, you can sort of invoke that contractual right to force arbitration on the other side. Now, the benefit of arbitration is it tends to be a little bit more of a condensed timeline than state court. It's supposed to be a little bit more efficient. Economically, though, they can be very expensive. Some people, they're often pitched as really economic.
Sure.
But the reality is there's a lot of heavy lifting in arbitration as well.
I bet.
So, but those are binding. So if you,
right.
That's a huge difference than mediation. So if you take it to arbitration, which would likely be after the mediation didn't resolve, you go through the arbitration process. The arbitrator has the right to award a party, right? And you have an arbitration award. Once you have that document, you can then take it to the state court, and they'll stamp it, and it becomes enforceable at that time.
Sure.
Okay.
So it becomes an enforceable award.
Now, in the years that you've been doing this, when you see a tyrant on there on the board, in terms of just rough percentages, 1 out of 10, are most of them solved in informal dispute resolution?
Yeah, so success rate for mediation tends to be high. But what I tell everybody, because I get asked this a lot,
Sure.
is we could have a 100% success rate at mediation, but that's not going to have any bearing on whether or not your case is going to resolve.
Right.
Because you're dealing with human beings, right? I don't have a crystal ball. I can't gauge whether I'm going to get a reasonable board that shows up or a reasonable lawyer, right? I mean, you can get a reasonable board, but you get a Rambo lawyer on the other side who just wants scorched earth and shuts the whole thing down.
Right.
So you can't really predict who shows up on the other side.
Sure.
Now, you'll start to get a gauge from it, though. After your lawyer sends the demand for ADR, there's going to be some negotiations before the mediation. At that point in time, you can start seeing who the players are on the other side. What is their position? And at that point, you'll have a little bit of a better gauge of where this mediation might go.
And how flexible they're willing to be.
Correct. Yeah. But beforehand, it's very challenging to say.
Now, I don't think we've ever mentioned this, but in many cases, you have multiple homeowners come to you together for one case, right? To represent a group of homeowners. Is that not correct?
Yeah, we see groups every now and then because often the homeowners are experiencing sort of an equal dissatisfaction with the HOA.
Yeah.
They're all being harmed in some way. Maybe everyone's fair market value is being dropped, or there's some sort of impact that's very negative to their life in the association.
Yeah.
What I often recommend, though, at least for this firm, for us, it's much easier and efficient to represent one homeowner and drive that forward, even though it's on the behalf of everyone else, right? If they prevail at the or if they settle at the mediation, it's going to have a trickle down effect.
Right.
When you have 4 or 5 homeowners, it just becomes very clunky representation.
I see.
Now, I think some law firms are probably maybe better equipped to handle multiple parties, but at least for this firm, it's very efficient to have maybe 1, 2 at best homeowners and driving a case forward.
Yeah.
So,
Okay.
I was just thinking in terms of sharing overall costs. If the tyrant is out of control and you get ton of pushback from the other side and you're getting into the worst case scenario and you're having to go to litigation and it's going to be somewhat expensive.
well, what happens though on those cases is we may represent, party 1 or homeowner 1. It's not uncommon for them to cut deals on the back end to help fuel the litigation. We don't get involved in those types of relationships economically, but you may have 7 or 8 homeowners who are actually help funding the one. So that is an option.
That makes sense.
My firm doesn't get involved in those dynamics.
I understand.
But that is an opportunity for them.
Understood.
And I've seen that before.
Yeah. Makes a lot of sense, actually.
Yeah. No, it's more effective.
Because the worst case scenario is you get this, you just feel trapped and totally stuck. And
Correct.
It's either you pay a boatload or you have to deal with this guy for however long.
Correct.
And if everyone's in cahoots on the board, it's going to be difficult getting him removed.
Correct.
Yeah.
And there's ways to do so, but I think to your point, there are some economic realities to doing so.
Sure.
To enforce your
Yeah.
rights.
Yep.
All right, what else do we have?
You have any key cases or examples that you want to discuss? A couple of highlights that you think would be interesting to share?
Well, I have several that just rushed to my mind. We've seen a lot of tyrants. We had one client who had a tyrant for a board president, and it was a beautiful condo association. And essentially what the tyrant did was violated all the rules. There's certain restrictions on the patio use, what they could or could not put up. Their patio was in complete violation, and they were sticklers, though, with everyone else's patios, which is blatant. That's sort of black and white. It's like, hey, you're not following the rules, but you're coming after everyone else, who are also in violation, right? So everyone else had to be in perfect conformity other than the tyrant, right? So that was the problem there.
Yeah.
So the owner came in and said, it was gaudy. They had like all these statues and just very bizarre decorations on the patio that it was black and white violations of the CC&Rs, but the tyrant loved the statues, right? It was their thing. And so that turned out to be a big fight to get the removal of those gaudy statues out. And they really didn't have anything to say at mediation. We had pictures, we had evidence, we had the CC&Rs. It was black and white. And we also identified, the board's decision to go after people who had like small plants or, sort of smaller non-conforming issues. So we were able to hit the tyrant on, their own breaches of the CC&Rs, but also the selective enforcement or preferential treatment that was happening. And I think that tyrant ended up resigning from the board because, the next step would have been litigation.
Yeah.
And there wasn't much of a defense there. Now, they got away with it for several years because no one would enforce. They just turned a blind eye, right?
Yeah.
It was just one of those scenarios where, oh, that's just tyrant being tyrant.
Yeah.
But eventually someone's like, no, that's BS. I want to enforce. And when we saw the case, we're like, oh my God, we can do a very direct attack. We showed up at the mediation. Retired judge couldn't believe what they were seeing. They couldn't believe that this was outstanding for 5 years. No one has done anything. And it was, that was a very effective mediation.
Interesting.
Nice.
Yeah. All right, we have a curveball for you.
Hit me.
Okay.
I like
so,
curveballs.
So Reddit. You been on Reddit?
I'm aware of the platform.
There's a subreddit, aka a group,
Okay.
that is called, without using the word, it's FHOA,
I see where this is going.
and it's all people complaining and telling stories about how horrible their HOA is.
I probably know some of them.
Yeah, I'm sure. I'm sure there's one in there. So we thought it would be fun to cherry pick out a tyrant for you. And then so Jenny's going to read the actual post. We made some adjustments so it's a little bit easier to read.
Okay.
And then you can give your take on how you would approach that person.
Oh, this is fun.
Kind of from
Okay.
all right, from start to finish, and ramping up certain legal
okay.
ramifications.
I've never done
all
this.
right.
This is
The
interesting.
title is my favorite. HOA president is awful. As a homeowner in our community of 200 residences, I've witnessed a troubling sequence of events since our Homeowners Association was established a year ago. One individual, who has been ambitiously eyeing the presidency from the start, embarked on a campaign to secure votes by canvassing door to door and distributing flyers. Upon securing the presidency, he enacted significant changes, dismissing our original management company, contracting a new one, appointing a new HOA attorney, and instituting a ban on ATV use within our neighborhood. The remaining board members seemed to support these actions. However, the situation quickly deteriorated. The president exhibits an intolerance for dissent. During community Zoom meetings, he has muted and expelled participants for any hint of criticism or negativity, contrary to our HOA's established rules that promised open dialogue. Furthermore, he has resorted to publicly chastising homeowners via community-wide emails, displaying a penchant for pettiness and hostility. Our community's Facebook group, a platform for open discussion, has become another tool for surveillance under his watch. Any contentious posts are swiftly removed by an admin, and the president has an assistant print and deliver these posts to him, creating an atmosphere of fear and self-censorship. The professionalism of the newly hired management company is concerning. Led by a single individual, the company frequently issues poorly written communications and fails to adequately address homeowners' inquiries, deferring matters to the board, which then remains unresponsive. The acratic nature of our HOA president was starkly evident when a homeowner who criticized him on our HOA website was suddenly unable to access his account. The management company's response was dismissive at best. In a bold move, this homeowner distributed a letter outlining his grievances to every household in the community via hand-delivered letters to each, only to be met with a no trespass order from the president, backed by law enforcement, severely restricting his movements within our own community. What steps can we take as homeowners to gain control over the community?
That is a lot to unpack. All right, give that to me real quick.
I'm like, I don't even know where you begin, but
Well,
this is why we're here.
There's a lot of questions here too, though, and I'll analyze this under the lens of California law. Can I see the?
Oh, this is serious. He's getting a pen. We're underlining here.
Yeah. So how am I seeing this? So
Maybe start from the top.
Well, no. Some of the themes that jump out. Well, one, I think there might even be a false imprisonment claim with the restriction of use. So that might be false imprisonment. In terms of restricting access, I would want to see how tightly that was contained.
Are you talking about the restricting access to the platform, the website?
No. I thought there was something where they actually restricted the use of land. That would be a far stretch one, but I would want to investigate that.
Well, like the ATV no use policy?
No, that's not it. Where was this one? That jumped out at me immediately. All right, I'll put the false imprisonment one aside. I would have to look at that a little bit more carefully because that would be awesome if you could go after them for false imprisonment.
Why does that?
Well, that's a big violation of rights. And we had a case once. This was a Florida case, but essentially what happened was this was during COVID, and one of our clients, they got COVID, they caught COVID, and the association actually locked them in their unit. They didn't let them leave. Now that's extreme, right? I mean, that's so
In
extreme.
Florida?
In Florida. But the restriction of movability, right? To lock someone down. I don't know how egregious this was. I would want to explore that.
Yeah.
There might be defamation claims when they're putting people on blast. You'd have to assess that.
What about the removal of accounts?
Or no access is
Right.
Well, no access might be a lack of transparency. There might be violations of the Davis-Sterling Act here. There might be self-dealing. Often when you see a board president who all of a sudden inserts a new management company, it'd be interesting to see the relationship between the two. Now, you're not necessarily going to know immediately whether self-dealing is happening, but let's say this really escalates and now you're into actual litigation and you see checks being kicked back to him personally, right? He hires a management company. It's like, we'll pay you $10,000 a month to manage the community. Well, all of a sudden, though, you see the $10,000 go out, but you see a $2,000 check come back.
Sure.
Right? So there might be some elements of self-dealing here.
Okay.
That is very high level. I mean, you might have breaches of fiduciary. You might have breaches of the bylaws or the CC&Rs when they're shutting people down in the community, shutting off their ability to speak freely.
Yeah.
So you're going to have probably a laundry list of causes of action. The question, though, is, okay, what do you do with that?
Yes.
Right? How do you enforce that? This, in my mind, I would avoid IDR like the plague. I think it'd be a waste of time. I would probably also discourage the owner to hire a lawyer to send a demand letter. If this attorney is in bed with this president,
Which it sounds like, I
Yeah.
mean,
Correct.
he fired the property management and the attorney right from the onset.
Yep.
Is
Yeah.
yeah, he's stacking the deck. So I would imagine that a demand letter would hit that attorney's desk. Maybe there's some good faith negotiations, but I don't think that they're going to go anywhere.
Okay.
And
so what
again, I
would
don't
you
have
do?
all the facts here. I mean, I have a good amount of facts, but IDR might be a waste of time. So homeowner-driven IDR, you're going to get shut down, or I'd anticipate you would. A demand letter from a lawyer might be a waste of your money, meaning you're hiring a lawyer to send a demand letter to negotiate. But again, this is the negotiating with the wall.
But you're assuming when you're sending a demand letter, you're going to assume that it's in good faith.
When we send it, it's
Right,
in
right,
good
right,
faith.
right.
The response, though, may very well be in bad faith because that attorney, the well may already be poisoned.
Right.
Now, a cunning lawyer on the other side would do this. Oh, I got your letter. This is horrible. Let me investigate. And all of a sudden, you're negotiating back and forth. It's 6 months down the road. You spend a good deal on your lawyer to negotiate. And 6 months, the attorney says, yeah, thank you so much for your time. Go kick rocks. We're not going to do anything. Right? Now you just blew money and time.
Yeah.
So I think IDR might turn into a money pit pretty quickly and not get traction. This one, likely ADR. Start with ADR and see if you can get some pressure on them immediately. I would also recommend a corporation's demand. Or under the code, you can request certain financial information.
Okay, so
That might be a powerful tool here just to get some transparency out of it. Now, the issue with ADR versus litigation is you don't have all the discovery mechanisms.
Oh,
So
interesting.
in litigation, you can call this tyrant in for a deposition. You can subpoena bank records. You can do so much. But in ADR, you really don't have that power. If they agree, great, they'll turn it over. But if they don't, you can't run to a judge and say, hey, they're not turning this over. So you're a bit more limited, but that would be the opening attack on this situation. I think it would be ADR. I don't know what state this is. I don't know if they have those types of provisions. But at least in California, obviously there'd be a little bit more due diligence on our part to confirm this strategy. But I think ADR would probably be appropriate.
At least a
Opening
good
move.
starting point.
Yeah. IDR seems like it would just be a complete waste of time.
And I would assume you should, just like we said earlier, as soon as you start seeing the red flags, start collecting evidence
Exactly.
immediately. And it sounds like there's multiple homeowners involved here that can start collecting evidence. And is that beneficial to have multiple homeowners start collecting evidence?
I think the more evidence you have, the better. Eventually you'll maybe consolidate it under one file.
Sure.
And then one owner will take the lead or in terms of the attack.
Yeah.
So, no, the more the better. The more you can show that this guy is an absolute tyrant and out of his mind, the better, right?
Yeah.
And when you can start showing breaches, though, that's where it matters legally. They breach their fiduciary, self-interest, maybe self-dealing. There might even be some form of invasion of privacy potentially. There might be violations of their own bylaws. They're not following protocol. I mean, there might be a lot of stuff. When you actually jump into this and start unpacking it,
Yeah.
you might be able to come out with a world. False imprisonment, though, I do have a question mark because I don't know if I was right on that.
Sure.
I'm trying to read for it. I don't see, maybe I misunderstood what you said. But you would review all of these and see, okay, which cause of action would you want to lead with? What's the support of that? And then once you have that framework, that becomes the basis of your ADR demand. Because also with ADR demands, you want to make sure they're comprehensive. You want to make sure any lawyer who picks it up on the other side says, oh my God, they've done their diligence.
Yeah.
They've crossed their T's, they dotted their lowercase J's. You've got to make sure that you come well-heeled, because the other side, the opposition, you want them to know, okay, they've done their homework, they've done their investigation, they're not messing around, versus an ADR demand that's just skeletal. I see those all the time. It's like, hey, we're upset because of this. We hereby demand ADR. Okay, you spent like $8 on this letter. Go kick rocks. No one's investigated.
Yeah.
But that was a fun one. Maybe I'll read this Reddit.
Yeah, you're gonna be trolling that now. Just,
Yeah. So that was good. That was fun.
Yeah. No, that's interest. That's certainly interesting.
I don't know. Did I pass the test?
No, I
I know, I liked it.
I found it really interesting. So the next episode's a fun one as well. The incompetent.
Oh, the incompetent. Yes, I like the incompetent. Yeah, so maybe I'll tease that one.
Yeah.
So the incompetent operates in its own sort of vacuum. They're not a meddler, they're not a tyrant, and sometimes the interesting thing with the incompetent is they're very good-willed. They have goodwill. They want to do the best for the community, but they don't understand anything. You know, the complexity of a director can't be understated. When you're in a director's seat or you're on the board, you're dealing with fiduciary relationships, you're dealing with CC&Rs, you're dealing with corporate governance, you're dealing with state law. And you have to understand all of these things to operate effectively. Because again, I don't want to be perceived as someone who's against associations. When they're properly run and maintained, they can be a great thing. They preserve fair market value, and it actually can be a very positive thing.
Yeah, you yourself live in an
Correct.
association.
Correct. And it runs very well. Knock on wood.